Finally, a change of terminology would really help clarify the issues. A glaring point is to do away with the difference in the family code between void and voidable marriages, such that marriages tainted by fraud, violence, undue intimidation, etc., would not be merely voidable, as they're called now in the family code, but rather void, ab initio. Because if you think about it, what's the difference between void and voidable? For those of you who are lawyers there, is one of the discussions that I hope you got into. And if not, well, I just wish you were in my class instead in matrimonial law, because I really believe at this point that the difference between void and voidable is absolutely, pardon me again, because I don't mince words with these things, stupid. You know? One consequence of this is that under Article 39 of the same code, the parties to such marriages will still have a remedy available even beyond the 5-year limit currently imposed under Article 47 of that code, and would not be limited to psychological incapacity under Article 36 of that code to have their marriages declared null and void from the start. And here's a little aside. Unfortunately, as I said, when the family code was crafted as a concession, because they really, some people wanted divorce, but okay, that's divisive and it's against the values. And besides, we were under Cory Aquino at that time, so they instead imported something from the Code of Canon Law, and I have it in my conscience that at that time when I was consulted by the nunciature, no less, how that family code was, I said, no, it's okay. It's taken from the Code of Canon Law. At that time, I was very young. I was a very young priest. I didn't have enough experience. That little did I realize that, yeah, it was taken, but taken very defectively. No? They just got Article 3, Canon 1095, paragraph 3, precisely the so-called psychological incapacity. And it just so happens that that particular ground is one of the least used grounds in nullity cases. Because I always say this, no, that normally for the greater part, people are psychologically normal. Because it's a curve, di ba? The so-called normal curve, the bell, it's also called the bell curve for those of you who have taken the statistics in college or in high school. It's called a bell curve, or it's called the Gaussian curve, no? The Gauss curve. It's like that. That the great part of the population is there in the normal, and then there are very few incidences in one side or the other of normalcy. This normalcy. No? So the great there are there, either under normal or sobra normal. No? But then the little symptotic curve there at the ends, very few people are abnormal psychologically. That the preponderant majority are normal. So therefore, psychological abnormalcy as a ground for a dysfunctional marriage will seldom happen. Now, unfortunately, precisely that's the only thing that was imported by the family code. Ano nga mangyayari? So they have to massage everything to that thing, which is not real, by the way. So many of the declarations of nullity in civil courts is moral, psychological incapacity. I once adjudged a case in the ecclesiastical tribunal that had been adjudged in civil court already, and on the ground of psychological incapacity because the husband was homosexual. I remember interviewing the driver, no? May napansin ka bang, kabadingan dun sa boss mo? The guy told me, Father, wala. Actually, ang problema talaga dyan kung saan sa ang beer house ko nga siya hinahatid. Dahil babaero talaga yung boss ko, no? So, the problem was the opposite, no? Then when I interviewed the guy, I asked him, ba't ganun? And then you know what he told me? Well, I wanted out. I got a lawyer, and that's what they said. And he made the case based on that. Ewan ko, paano yung ginawa yun? Very easy. you get a psychological evaluation, you pay the person, and you get it. That's the reason why civil nullity or annulment cases are so expensive. The typical package for annulment in civil court is 300,000 pesos. Papataas. I have a client uh, who has already spent 600,000 pesos, hindi pa rin niya makuha-kuha because he happened to be raffled off to a judge who considered herself a very good Catholic, daily mass goer, and she systematically was making all kinds of problems because she didn't want to grant an annulment in court. So delay and delay, delay and delay. Actually, it was already the lawyer na awa na sa kanya and say, Sir, awang-awa na ako sa'yo, 600,000 na, wala pa rin nangyayari. Let's just drop this case. Let some time pass and refile it in another tribunal. And that's what exactly happened. No? So that's the problem. And that's what's in the mind of the pro-divorce camp. They see that reality, ang hirap-hirap kumuha ng declaration of nullity or annulment, mas madali itong divorce. So what we need to do is to offer a solution, not to go into the immorality of abortion, or rather of divorce, or the church position. That's old. That's old argument. No, you can argue that until you're blue. Hindi tatalab yun because there's a problem. So you have to address that problem, no, and uh, and not argue in a different reason, no, separation of church and state. No. Now, another step in the same direction would be the consistent use of the expression declaration of nullity of marriage instead of annulment of marriage. In the former, the competent tribunal is rectifying the fiction of law, fictio juris, created by the celebration of a marriage with due form, but which is subsequently proven in a judicial process to suffer a defect in the consent or even in the capacity of one or both contractants. By declaring it null ab initio. In this case, there is no annulment, which would be tantamount to divorce or to the dissolution of a valid marriage bond, because the court precisely declares that such a marriage never existed. There's nothing to annul. Absolute divorce proponents frequently cite the expensive and tedious process of obtaining a declaration of marriage nullity. Here again, canon law provides a model in Pope Francis's Motu Proprio Mitis Judex Dominus Jesus, promulgated in 2015. Because among the reforms that it introduced was a so-called briefer process for cases where both parties are in agreement to file for a declaration of nullity. So there's no contest, in other words, and the presence of certain circumstances which, while not of themselves grounds for the nullity of marriage, are indicators, they're indicative, that such a nullity may be of easy judicial demonstration, easy instruction, therefore, easy proof. So therefore, such cases can be done in the so-called expedited or briefer process. Just one meeting. I have made, I think I hold the record in the briefer process with the Diocese of Antipolo. Once we adjudged the case in 2 days. Because it's clear cut. Everything is there. Just one trial, no objections. But mo papahabain if it's clear, no? So therefore, we were able to do it. So it's not true that a good process, a thorough process, need to be long and tedious and expensive. What you need are the right frameworks for doing it quick, clear, and inexpensive. And it can be done. That's why church process, normally, even without the briefer process, what's the cost of a church process? In Manila, 60,000, even 40, and in the provinces, even cheaper. While versus the civil case, it's 300,000 from the beginning. Given the ample range of possibilities and options provided by the proposed reforms discussed above, the legislation of absolute divorce becomes unnecessary to address truly meritorious cases of irreparably broken marriages. So, with that, I end my presentation to give us some time for the open forum.